Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers HIPAA laws, recording in public buildings, and trespassing on public property, and is brought to us by Blind Justice's channel. Be sure to check out the description below and give them the credit that they deserve. Let's dive right in and audit the audit. On February 4th, 2020, the visually impaired auditor, who was identified as Mike Nelson in this local news article, entered the Guilford County Health Department in the city of High Point, just outside of Greensboro, North Carolina. Mr. Nelson was seeking information about the mental and reproductive health services available from the department when he was contacted by Officer Robertson of Guilford County Security.
Who are you?
You don't need to know that. You just need
Okay.
to
Well, you can't give people orders unless you identify yourself. So.
Yes, I can.
Okay. Well, your orders are invalid.
Well, we'll see.
Okay.
Officer Robertson refuses to identify himself to Mr. Nelson and attempts to kick him out of the building for recording.
Are you filming me?
What's that?
Are you filming me?
Film? Oh, no, we don't use film anymore.
Okay, well, recording.
Part of the
You
department.
have to leave. You know that, right?
What's that?
You got to leave. You can't have people just kind of sitting around. I like to talk to you.
Uh-huh.
You got to leave.
At one point, Officer Robertson decides to turn Mr. Nelson's camera to face the opposite direction without permission.
Well, yeah, I went to social services, but I didn't get the whole rundown of everything. Some of the stuff is.
Turn to your camera.
Oh, why?
So you were not filming me.
Oh, please don't touch my things.
But that's against the law.
What is?
To film me without my permission.
Oh, actually, that's not true.
Yes, it is.
Do you know what law that is? What law is that?
My law.
Your law.
Right.
Well, who are you?
You need to leave.
You touching my camera is actually illegal, sir.
It's illegal for you. No, I didn't damage your camera.
No, but you touched it without my permission.
Your camera, you can't see, right?
You're telling me to leave again?
Yep.
Okay, who are you?
Don't you see me?
No. Are you wearing a name tape or anything?
No.
You're not?
Yeah, I have a nameplate.
Okay. I can't see it. Can you tell me what it says?
No.
You can't tell me what it says?
You don't ever need to know.
I absolutely do, sir. You actually touched my property without my permission, so that's a crime. If I want to report that crime, I need to know your name.
We close in approximately 10 minutes.
Will you at least tell me who you work for? Like, are you sheriff's department
you need
or?
to leave in approximately 10 minutes.
Okay. At least tell me who you work for.
You don't need to know that.
Oh, I absolutely do.
After several minutes of unproductive bickering between Officer Robertson and Mr. Nelson, the building's manager intervenes.
I'm sorry, who are you looking for?
An administrator, some kind of building manager.
Okay, well, I'm over the building.
Okay.
So I'm going to ask you one time to
Uh-huh.
please stop recording right now.
Well, who are you?
It is posted on the doors. My name is Leslie.
Okay.
It's posted on the doors. There's no video recording. We have clients here that are
Mhm.
here for medical reasons.
Yeah.
And you're violating their law, their rights.
What right is that?
They're HIPAA violations.
Oh, you know that HIPAA applies to the medical personnel, not to the public.
The Health Insurance Portability and Accountability Act of 1996, or HIPAA, is a federal law that required the creation of national standards to protect sensitive patient health information from being disclosed without the patient's consent or knowledge. Within the HIPAA Act, the U.S. Department of Health and Human Services issued the HIPAA Privacy Rule to implement the requirements of HIPAA. The Privacy Rule standards address the use and disclosure of individuals' health information by individuals and organizations known as covered entities. These entities include healthcare providers, health plans, healthcare clearinghouses, and business associates, and does not include the general public. However, citizens may still have a reasonable expectation of privacy inside a health department facility. In the 1976 Supreme Court case of Katz versus United States, Justice John Marshall Harlan established a two-pronged reasonable expectation of privacy test, which has become the privacy legal standard over the years. The test considers whether an individual has exhibited an actual subjective expectation of privacy and whether the expectation is one that society is prepared to recognize as reasonable. Like all legal precedents, rules relating to the doctrine of expectation of privacy are subject to interpretation, and whether a reasonable expectation of privacy exists is fact-specific and determined on a case-by-case basis. Reasonable expectations of reasonable people, locations, the nature of the objects or data, and many other factors must be considered. While Mr. Nelson may not be subject to HIPAA violations, he may still be violating other citizens' reasonable expectation of privacy privacy by recording inside the facility. After a brief debate with Mrs. Leslie, Captain Doherty and other officers of the North State Security Group arrive on the scene and order Mr. Nelson to stop recording.
How do I file a complaint or criminal report?
You can file that through Guilford County.
Okay. Are you his supervisor?
No, I'm not.
Okay. Can you identify him for me? Because I need a name to go with the complaint or the criminal
You can ask the
complaint.
officer, he'll identify himself.
Can you tell your name, please? Okay. So somebody read me the gentleman's name?
You need to turn your recording device off, please.
Okay.
I've
I use these as
asked-
assistive devices.
I understand your
for
assistive devices, but
reasonable
you are
modification.
recording. If you don't turn your devices off, your recording device, not your assistive device.
These are assistive devices.
Okay? If you don't turn your recording
Do you have
device off.
is there an ADA coordinator, Ms. Leslie?
You need
We
to
have
leave.
an ADA coordinator, not in this building, but you have been told to turn it off.
Okay, you need to leave.
But this is a
If you
violation
are not
of
going
rights.
to stop recording, you need to leave the building.
In the 1983 Supreme Court case of Perry Education Association versus Perry Local Educators Association, Justice Byron R. White explained that there were three categories of government property for purposes of access for expressive activities: traditional public forums, limited public forums, and non-public forums. In the court's forum-based approach, the government can impose reasonable time, place, and manner restrictions on speech in all three categories of property, but has limited ability to impose content-based restrictions on traditional or designated public forums. When determining whether a government property should be classified as a designated public forum, the courts examine the property's policy and practice, and whether the property is a reasonable place for expressive activities. Because the building's ban is strictly on the act of recording and not Mr. Nelson's expression of rights, the Guilford County Health Department's no recording policy is likely valid. However, in a statement issued after this interaction, Mr. Nelson claimed that he uses his camera and phone as assistive devices and records his encounters so that his spouse can help him navigate the areas he goes to. Subsection 4 of 29 U.S. Code 3002 defines an assistive technology device as any item, piece of equipment, or product system that is used to increase, maintain, or improve the functional capabilities of individuals with disabilities. It appears as though Mr. Nelson's cell phone recordings could be considered an assistive technology device, but the courts would have to balance the disability accommodations Mr. Nelson is entitled to with the public's reasonable expectation of privacy within a health department facility.
Okay.
Okay, I've asked you plenty.
Well, there was a crime committed, and I need to identify the person that violated that.
If you don't leave the building,
you're going to be arrested.
You're going to be arrested.
Trespassing right now.
okay?
So,
For
are you going to leave?
for second degree
Yes,
trespass?
now they're asking you to leave, and you're not leaving the county building.
So hold on, second degree trespass is
Okay.
if you're on the
Are
property
you gonna
of ano-
leave?
I'm trying to clarify what's going on. So second degree trespass is if you're on the property of another and you're without permission, or you are asked to leave or told to leave and you refuse. Is that right? Is my understanding of that right?
Whatever it is you want it to be.
Well, I just want to understand what you're threatening. Like if
I'm
you're
not threatening you.
Nobody's
Are you going to
threatening
leave, sir?
Well, I'm trying to clarify.
Are you going to leave, yes or no?
You've been
Absolutely,
asked to
yes,
leave.
I will absolutely leave.
Let's go.
I'm just
Okay.
trying to clarify
Because now I'm about
what's
to
going
percuss
on.
on you if you don't.
Just as public employees do not work for any individual taxpayer, public buildings do not belong to any individual member of the public, and government buildings are generally considered the property of another for the purposes of trespass laws. In the 2016 Texas Court of Appeals case of Wilson versus State, the court held that government entities have the same rights as private property owners to control their properties, so long as the entity's policies are not employed as a subterfuge for illegal discrimination. North Carolina Code 14-159.13 states that a person commits second-degree trespassing if they remain on premises of another after being notified to leave by the owner, by a person in charge of the premises, a lawful occupant, or another authorized person. But banning an individual from public property is subject to certain legal guidelines. A trespass should not be based on a person's decision to engage in conduct protected by the First Amendment, such as protesting. But the 2015 Idaho Court of Appeals case of Pentago versus State held that individuals may be banned from a building for reasons unrelated to their expressive conduct. Banning a person from a building that houses essential government functions poses significant legal challenges, but public officials may seek alternative means to banning an individual, such as having them escorted while they are on the property. The laws and legal nuance surrounding trespassing on public property vary from state to state and municipality to municipality, and it is difficult to say whether a court would consider Mr. Nelson's trespass valid.
Wait a minute, so you are going to use violence against me? I'm trying to clarify.
Not violent.
Like, taking away my freedom is absolutely violent.
Sir, Are you gonna leave right now or not?
Yes, I'm trying to clarify.
go.
What do you mean by
Let's
secondary
go.
trespass?
Let's
Because
go
You
out
have
here
5
and we're
seconds,
gonna
I'm gonna take you,
clarify.
turn around, put your hands behind your back,
A
and then
property,
you're gonna go
a
to jail.
property of another, that means it's,
All right,
you
go
know,
ahead, turn
this
around.
is, what are you doing? Whoa, 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 whoa.
In Mr. Nelson's post-encounter statement, he claims that Officer Boyce of the North State Security Group grabbed him by the arm, threw him to the ground, and placed him into handcuffs. The officers then dropped him onto a wheelchair, injuring his neck, and forcefully wheeled him into the county courthouse. Mr. Nelson says that he woke up 5 hours later in a hospital, where he discovered that he had been picked up by EMTs outside of the local jail. The original interaction began at approximately 4:40 p.m., and documents acquired from the city clerk state that he was released from jail at 7:02 p.m. While in the hospital, Mr. Nelson was diagnosed with a 6mm bleed on the brain and many other less serious injuries. Mr. Nelson spent several hours in the hospital, but was eventually discharged into his wife's care and is now stable and recovering. Mr. Nelson was charged with second-degree trespassing and resisting an officer. The Blind Justice Channel has been tirelessly seeking legal representation to fight Mr. Nelson's charges and pursue civil suits. Overall, Officer Robertson gets an F for refusing to identify himself, violating Mr. Nelson's private property, and taking advantage of Mr. Nelson's disability. At several points throughout this encounter, Officer Robertson acknowledges Mr. Nelson's visual impairment and refuses to provide any reasonable proof of authority to issue orders. Any non-impaired individual would have had the visual context clues necessary to ascertain the officer's name and agency, but Officer Robertson took advantage of Mr. Nelson's condition and refused to offer the same degree of identification that he offers to any non-visually impaired individual that he makes contact with. It could be argued that Officer Robertson's actions were ethically questionable and possibly discriminatory. Either way, they were not the actions of a law enforcement professional, and Officer Robertson should be held accountable for his negligent behavior. Mrs. Leslie and the responding officers of the North State Security Group also get an F for asserting their administrative authority over Mr. Nelson instead of attempting to make a peaceful compromise, causing serious physical injury to a passively resisting citizen and completely disregarding Mr. Nelson's claim to disability accommodation. Mrs. Leslie and the North Star officers were so concerned with enforcing their no recording policy that they refused to seriously consider Mr. Nelson's condition and the assistive devices he uses, and whether or not an exception should be made. That decision is ultimately for a court to decide, but the North Star officers ignored Mr. Nelson's explanation for the recording altogether and escalated the interaction into a physical altercation, resulting in the arrest and injury of Mr. Nelson. While I do not fault the officers for attempting to enforce the building's policy, it is difficult to understand how a disabled veteran recording himself inside a government building resulted in a violent arrest, jail, and a brain injury. Mr. Nelson gets an A-, because although there may be an exception for recording via his medically assistive devices, a valid argument exists that those recordings could violate the public's reasonable expectation of privacy while inside a health department facility. It could also be argued that the security officers and Mrs. Leslie did retain the authority to stop Mr. Nelson from recording because their policy was based on the act of recording itself, and not the act of protesting or demonstrating. There is a legitimate state interest in protecting the privacy of citizens conducting business within a health department facility, and it is unlikely that a court would find the health department's no recording policy in violation of the First Amendment. But given that Mr. Nelson's phone could be considered an assistive device, it makes for an interesting courtroom scenario. Be sure to follow Blind Justice's channel for updates on Mr. Nelson's condition and future legal battles. Let us know if there is an interaction or legal topic you would like us to cover in the comments below. Thank you for watching, and don't forget to like and subscribe for more police interaction content.